I will wait till YouTube starts. Oh, I see we just started it. I first want to apologize for getting a late start this morning. I understand one of the council, I guess, had difficulty getting in or wasn't on time. So I apologize. We are a little behind schedule. We've got quite a full docket today. We have 4 cases that will be argued. The first case is Williams versus Williams. Ms. Stagnaro is here on behalf of appellant. Ms. Bonecutter is here on behalf of appellee. Ms. Stagnaro, you will have 15 minutes to argue. Would you like to reserve any of that time for rebuttal?
I would, Your Honor. I'd like to reserve 5 minutes, please.
All right, and whenever you're ready, you may begin.
Thank you, Your Honor. We are here today on an appeal from the Hamilton County Domestic Relations Court. It was a post-decree matter filed in the court by my client. And the reason that we're here is that she had filed a motion for relief from judgment. The divorce decree had been put on by the parties in January of 2020. Her motion for relief from judgment was filed on November 6th of 2020, so less than a year. And the reason was around the division of the parties' retirement assets. So that when the issue came up, when the division of property order was being prepared by Ms. Zell, who was the expert retained for that purpose, my client realized that she had not understood how that plan was to be divided. When she actually looked at that documentation, that was some time.
Well, let me ask you this. I mean, this sounds like an issue of unilateral mistake, and normally we don't grant relief if one party doesn't understand something, but there's no objective manifestation of that.
And I understand that argument, Your Honor. However, I think this was a mutual mistake. And the reason I believe that is if you look at the language in the divorce decree, it is clear that the parties did not understand how they were supposed to divide the OPERS, or the Public Retirement Fund. When we talk about division of an OPERS fund, for example, a state retirement fund, we have to talk about how we're going to actually divide it. There are mechanisms to divide it. It is not a situation like a 401k where we can take money from that plan and give it to the other party as part of a withdrawal or a transfer of funds. And if you look at the language that was
but I guess then the question is, like, wasn't she being advised by an expert that would have explained that to her? Like, where, I mean, this obviously OPERS is complicated, as we all know, and but these are details that someone should have figured out beforehand.
Well, I guess I don't disagree with that. However, it wasn't just my client or her counsel not knowing that. It was also the other side and the other counsel. Because, we're in a situation in a divorce case where if somebody says, here is the language we agree on, the other party could easily say, no, that's not how we divide a property or a public retirement plan. This is the language we have to put in it. For whatever reason, that was not done. And this was an in-court settlement agreement that was just put on the record at the time of trial. That was later followed up in a divorce decree, and it wasn't drafted properly by both parties. Both parties had responsibility. Both parties must have had a mutual mistake on how they were supposed to divide that asset.
Well, so, isn't the way it would be divided if you wanted to split it 50-50? I think it's partly what you suggest, which is a joint and survivorship. But that would totally change the agreements of the agreement of the parties, wouldn't it? Because it would reduce his payments. He wouldn't get as much.
Well, yes and no. I mean, I think there is going to be a reduction, somewhat of a reduction in both parties' payments because of the annuity. However, that is, if you look at that in combination with my client's potential exposure, and that is, say we're in payout status, it's been a year of payout status, and then Mr. Williams passes away. She loses the rest of her benefits. And the way OPERS works, she doesn't get a lump sum. She gets what the actuaries determined to be a payment per month for the rest of her life. So she could be losing thousands and thousands of dollars. So her 50% marital interest is out the window if that were to happen.
There's some way to get partial upfront, PLOP, P-L-O-P. I mean, I guess these are all things that Judge Bergeron raised. Shouldn't this all been discussed ahead of time? And a quick phone call to PERS would have figured it out.
and I was not there. I was not the trial attorney. Neither was Ms. Brinkman for my client, who eventually took over and filed the 60B motion. I guess I don't disagree with that, but should my client be punished because both parties didn't put in the correct language, didn't do their due diligence, contact an expert to start that process before the divorce decree was put on? You know, what we're looking at is the intent of the parties was for my client to receive 50% of the marital portion of this fund. By not putting in place the pre-retirement life insurance policy, by not putting in place the joint survivor annuity, she is risking, or has the risk of not having her 50% that was awarded to her. With the pre-retirement life insurance, that I think that is something that should be a no-brainer. And the reason I say that is there's no risk to Mr. Williams, because she would be paying for that at her cost, and it would be in place in the event he were to pass before it would go into payout status. So he's not out any money. His benefits are not being reduced. It is a gap insurance to protect her interest until she starts receiving it. And
couldn't she do that? Couldn't she put a policy on his life even after he starts getting retirement funds, and that would protect her?
It is certainly possible to do that once that benefit is determined, but that would also require his cooperation.
This isn't in our record, but I take it that he has refused to allow that?
Well, he refused in the sense he didn't agree with it. So his testimony was that he did not want that to be part of the court's order. He didn't really have a good reason for that. He was concerned, I think, that my client might do something to him in order to get those life insurance benefits. But basically what his argument was, we didn't talk about that before the divorce decree was entered, so that shouldn't be ordered. That was the gist of his argument at the hearing. But I think that the bigger issue, and we're looking at the 60B, we do not have to prove our claim. So as far as what this court is doing on a review, all we need to show is that we have a meritorious claim for the court to actually consider it. And the court didn't consider the merits of the 60B. The court summarily dismissed it, believing that it didn't have jurisdiction to actually entertain it, which was inaccurate. The court, certainly by the Supreme Court's decision in Ostanek, says that the 60B does not divest the trial court of jurisdiction to hear a 60B, number one. But number two, because of revised code 3105.8.1 and 8.9, the court has the ability to look at the intent of the parties and fashioning an order regarding the division of a public retirement plan.
Let me ask you a question about the Ohio Revised Code 3105.171. That allows the court to retain jurisdiction regarding an implementation of an order. And do we have an implementation of an order here, or do we have a request to modify the order itself? And isn't that different?
It absolutely is different. And we are looking for a modification to add those two pieces that I've talked about. One is the pre-retirement life insurance policy, and also the joint and survivorship annuity once in payout status. So then
doesn't the statute prohibit the court from doing that?
It actually does not, because of 3105.8.9. So I would agree with you in certain property division circumstances, without a reservation of jurisdiction, the court cannot modify its decree under 3105.171I. However, because of 3105.8.9, when it deals specifically with public retirement division orders, if it's not, the language isn't in there, which it's not, to deal with that division, the court has the ability to modify the decree.
I misasked my question, and I see now how I misasked it. I guess what I was asking is 3105.89A only allows the court to retain jurisdiction if it's the implementation of an order, which I think you and I maybe agreed that this isn't implementation of an order, it's modification. And B, section B wouldn't apply because the order wasn't issued prior to the effective date. Where is that? So how does the court have jurisdiction?
The way I had written it, and I don't have the statute right in front of me, but I thought that the court had jurisdiction to modify, supervise, and force the implementation of the order. So in order for it to comply with 3105.81, and because the decree does not comply with 0.81, the court has the ability to modify the decree to make sure that it does comply with that order.
So, your reading is the word implementation only modifies enforce and not modify supervise. I'm sorry, because I know you don't have the statute in front of you, but I think I understand your argument. Your argument is that A allows modification.
Right, and only in the sense that it allows the court to put in place the requirements of 3105.81. And it's very specific in what is required in these orders, and that language was not in the divorce decree. So the court has the ability to modify the decree to comply with that code section.
And you are at your time, I realize, because we asked you a lot of questions, but if you'd like to reserve 5 minutes, you are at your time.
Thank you, Your Honor.
Ms. Bonecutter, you have 15 minutes.
Thank you, Your Honor. I think that the record is clear, and I was involved in the trial order. This is completely different. I do not think the court has jurisdiction in the cases that were cited by plaintiff. The fact that she was unaware, even though her testimony is clear that she said she only saw one page. Well, even if the one page she saw, it clearly states that OPERS is a qualified pension plan. If she had any questions for that, she was advised by counsel. She had counseled the entire time. And in fact, part of the discussions before we settled the day of trial included that my client took a bulk of the debt because he could pay it, because it was understood they would not be getting any retirement, either one of them, until he retired. So the fact that she was unaware it was not going to be an immediate lump sum, I wholeheartedly disagree with. Otherwise,
let me interrupt you there. The intent of the parties, and maybe I'm wrong, but if the intent of the parties was that she will get 50%, and let's say it's 50% of when he starts getting payments, how could she ever get 50% if he passes away very shortly after retiring?
Well, I don't know that she would, and clearly that was something she had counsel for and could have asked. The pensions are always an unknown number. In fact, it was, I think, specifically asked by her counsel, how much would it be? Nobody knows what that number is until you start drawing on it. If she had any questions, and the language that was put in the decree was simply because at that time they said they were going to hire a qualified domestic relations person such as Ms. Zell, or I think there was even another attorney that came in before her to divide this. The point is that none of this was discussed, and this is completely different because this was an agreement of the parties. This was not a trial order that ordered it. So the intent of the parties, if she's saying the intent of the parties was the same, it's not, it was different. And my client's testimony was that it was different.
So he never intended that she would necessarily get 50%.
Well, he intended that she would get 50% when he was drawing his pension, yes.
But I guess, as I understand it, like, she'll still get 50%. The only issue is if your client predeceases her.
Correct. So now they're asking that this court modify the order to say he has to choose a different survivorship benefit, which was not discussed or ordered, or was quite frankly not the agreement of the parties. And the fact that she just doesn't like it now or didn't understand it, I don't think that that's a reason or grounds, quite frankly, to grant the appeal. And in fact, the court in the argument that, yes, they had to rely on 60B, yes, she filed it timely, but this is now her third attorney, second domestic relations quadro person. It's the fact that she was claims unaware or not understanding how this was going to work. She had ample opportunity the entire time. The fact that she doesn't like it is simply the whole basis of this appeal. The trial court said that, even if you find that mistake was, as we just, I guess, discussed with the questions previously, Your Honors, was that even if the court finds there was mistake, that's still not jurisdiction to modify it at this time, because that's what she's asking you to do. Not only modify it, but include other orders such as life insurance that were never discussed and were never the agreement of the parties prior to her agreeing on the record that this was her agreement of the parties. So I think that the trial court was correct in denying her request for relief under 60B, as well as these other statutes, because these other statutes, quite frankly, don't apply. She's trying to find a loophole to say, well, you can maybe find under this statute, you have jurisdiction, and under this point, because of this, it's all the same, grasping at something that was never intended by the party.
Is there any downside to your client to agreeing, set aside whether or not you would agree to changing the structure of the OPERS, but simply to agreeing to allow her to insure him to hedge against his early death?
He's adamantly opposed to it. These parties have a history that's not, quite frankly, trusting or liking of each other. And in fact, I've never in my 24 years had life insurance ordered on a party post decree that was never discussed and when there was no children involved. He indicates that he doesn't trust her, and his exact quote was, "I don't know. This was not in the agreement. I don't know what her intentions are. Her intentions might not be good. They might be bad. And in fact, she would still get a second windfall if, she takes out a life insurance policy and she pays for it. Just the fact that she starts receiving the OPERS, if and when he dies, she would still get another windfall by insuring him. That was never discussed or agreed upon. So then she would get basically double dipping, because she would get the insurance proceeds as well as OPERS, presumably, until he passes."
Let me ask you a question about the decree. The decree says, it talks about the retirement plans, and it starts by saying plaintiff is entitled to 50% of defendant's 2 retirement accounts. Then it says defendant is vested in OPERS, which is marital and has an approximate value of $261,000. And then he's fully vested in an IRA, et cetera, et cetera. If the parties didn't believe that she was going to get approximately half of that $260,000 value at the end of the day, why even put any of that in there? And why not say that, doesn't that imply that she is entitled to 50% of the current value of that, as opposed to 50% of a payment that will start in the future and only until he dies?
It only implies that, yes, she gets her 50%, but the fact that the IRA, it was clearly discussed she was going to get half of that immediately if she wanted it. And I think her attorney at the time, Mr. Blankenship, even said there would be tax consequences to that. But the OPERS, which is clearly a pension plan, even my client says, I might retire in 1 year, I might retire in 4 years or 5 years, but even he didn't know what the exact number was. And that, again, is why their agreement included that he took on the marital debt, because she was not going to be getting, a lump sum payment up front from retirement. And nobody knew what that number was, quite frankly, and that it was understood at that time she was going to hire an Eileen Zell or somebody of that nature to prepare all the paperwork to make it accordingly. But I clearly think that the court doesn't have jurisdiction at this time to basically reinvent the wheel and say, now we're going to order life insurance that was never discussed. Now we're going to, put all these other factors and modify the decree saying it was the intent of the parties, when my client disputes that that was the intent of the parties. Thank you.
Any other questions from the panel for Ms. Bonecutter? Ms. Stagnaro, you have 5 minutes remaining.
Thank you, Your Honor. I want to expound on what you said, Judge Myers, regarding the language in the decree. First of all, there was a value listed, which is inappropriate when we're talking about a public retirement pension plan. That's clear in the statute. But also there's language in the second paragraph in that decree that talks about the division of property order or qualified domestic relations order necessary to effectuate the transfer of those funds. And that person would be responsible for any taxes if any of those funds were withdrawn. This is language we use when we're talking about a transfer of 401k funds, for example, that can be done in a lump sum, not when we're talking about a public retirement plan, which leads again to my argument that it is apparent that when this was drafted, the intent of both parties would be some sort of a transfer, and not that it would be weight and payments made upon retirement assets. So there was that mutual mistake.
May I interrupt you there? Let's assume that's true and there's a mutual mistake. It can't be corrected, can it?
It actually can be corrected. It can be corrected by court order under 31.
Well, let me, it can't, she can never accomplish the goal of getting half of that 260 outright. Either she'll have to be a joint in survivorship, which will reduce his monthly payment as well, or she'd have to, I guess, have life insurance as a gap in case he dies prematurely.
I would agree with that. And when we talk about value is not a fair description of her public retirement plan, because even though that may have been the value as of the date of valuation purposes for the divorce decree, my client is going to be receiving a monthly payment for the rest of her life. So they have to factor in all sorts of other factors when they're coming up with what that payment looks like. And there's cost of living adjustments and things like that on a yearly basis. So there is no value that we can really determine that she's entitled to, other than she's entitled to 50% of that marital asset as determined by the public retirement system. And I want to also address quickly Ms. Bonecutter's remark about my client would get a windfall if something were to happen to Mr. Williams and she has life insurance on him. You know, that's money that she's investing into the life insurance policy. So she's paying for it. If she gets money as a result of that, you know, that's not a windfall to her. She's actually incurring that expense. So I don't believe that's an argument that has merit. But
if you're right, isn't it as simple as her buying a life insurance policy on his life for $130,000 because she thought the value was $260,000?
Honestly, I don't know the answer to that. I think it would have to be determined. So I think she could get that amount for that pre-retirement potentially, but we're also talking about there's going to be some appreciation or additional credit because the date of valuation was 2019, and we're talking about 2-3 years later. So it could be higher than that, and we would need an actuary to say that. But as far as a life insurance policy after payout status, again, I don't know over her lifetime what ultimately her share is, but that's again something I think could be determined by an actuary.
If her mistake was she thought she could get $130,000 up front, then it doesn't really matter what the payout would be over her lifetime, because at least as I understand your argument, that wasn't the party's understanding. They understood they could just kind of divide it up and she'd get 130.
And I would agree with that. Ultimately, I just want to close with, ultimately the court's responsibility is to ensure a fair and equitable division of the party's marital retirement assets. If these items that we're asking for are not part of the court order, then there's going to be an unjust or inequitable division of marital assets, because there is a very real possibility with Mr. Williams' age, with his health conditions, with COVID, whatever, that he is not going to survive her. And if that happens, she completely loses either pre-retirement or post-retirement her marital share, which is not what the intent of the parties was, and certainly not what is fair and equitable for this court to do. So thank you.
All right. Any other questions for Ms. Stagnaro? Thank you both for your arguments this morning. We will take this case under. Ms. Baumcutter, were you?
Yeah, sorry. Thank you.
Were you trying to say something?
No, I lost you on the screen. I apologize, Your Honor. I thought I hung up. I was like, oh, thank you.
Thank you both very much for your arguments this morning.
This is why we miss you in person. We miss coming in person, Your Honor.
We are monitoring that daily, I assure you.
I understand.
Thank you all again. We will take the case under submission and give you a timely written opinion.
Thank you. Have a good day, Your Honor.
Ms. Hayden, if you will bring the next parties into the courtroom. Good morning, Council. The next case on our docket this morning is Mcquaid versus Mayfield Clinic. Mr. Schneider is here on behalf of appellant, and Ms. Frankowitz is here on behalf of appellee. Mr. Schneider, you will have 15 minutes to argue this morning. Would you like to reserve any time for rebuttal?
Yeah, about 2 minutes, Your Honor. Thank you very
All right.
much.
And whenever you're ready.
Good morning, and may it please the court. My name is Louis Schneider, here representing the Mcquaids in their appeal of the decision of the trial court, which granted summary judgment in favor of defendant Mayfield. Judge Allen's decision was based exclusively on the application of the statute of repose contained in 2305.113. I believe this court is very familiar with the statute of repose, considering the amount of cases that have come out of the first district with regard to the Durrani mess, and that's the best way to put that. With regard to the application of 2305.113 to the Mcquaid's claims against Mayfield, it's appellant's position that that statute does not apply. Accordingly, the statute of repose contained in that statute does not apply.
May I interrupt you and ask you a question about that? Is the claim against Mayfield a derivative claim? In other words, they are vicariously liable for the acts of the physician?
The claim against Mayfield is a vicarious liability claim. However, it is not defined as a derivative claim that's contained in the definition of derivative claim in the statute.
Okay, then let me ask you a follow-up. If the Mayfield's liability is based on the physician's liability, why isn't that a medical claim that's barred by the statute of repose?
Well, because it's just, it is a medical claim, but it's not a medical claim as defined by 2305.113. And
that's why I'm asking if it's a claim directly against Mayfield for Mayfield's negligence, or if it's a claim against the physician that you're trying to hold Mayfield responsible for. And does that matter?
It doesn't matter based on the language of 2305.113 and the application of that issue contained throughout various cases at the Supreme Court level that it basically said, you know, even if you have a vicarious liability claim against an employer of a medical professional, and that claim against the medical professional is bound by 2305.113, and you're pigeonholed into, you know, bringing a medical claim under 2305.113 against that individual professional, that doesn't make the vicarious liability claim or the claim against the employer a medical claim that is subject to 2305.113. It doesn't based on the language of the statute.
Thank you.
So yeah, it's not as if the claims against Mayfield Clinic are separate and apart. In other words, there's no claim of, you know, understaffing or, you know, negligent hiring or anything else like that. It's a vicarious liability claim against a physician that has immunity because he was, you know, teaching a resident at the time of the surgery. So, you know, his issue, he's not even in the case because of that. Instead, it's a claim against Mayfield as a defendant that is not a medical claim under 2305.
Well, let me ask you this. So there's two aspects to a medical claim under the statute, at least according to the Ohio Supreme Court. The first is that it arises out of the medical diagnosis, care, or treatment. And I mean, your complaint concedes that that's what this case is about, right?
My complaint does, and I conceded, and I believe I conceded it in the briefs. In other words, There's two requirements. The first one is it's a medical claim that comes out of the guy's back surgery. It doesn't meet the second requirement, which is it's against one of the enumerated providers that's identified in the statute. And that's why it's a medical claim that is not subject to 2305.1.
Because your position is Mayfield doesn't qualify as a hospital as that term is defined in the statute.
That is my position. It's also my position that it doesn't qualify as a physician, and it doesn't qualify as a home, and it doesn't qualify as anything under that. Instead, it's a physicians group it's not a hospital, it's not a home, it's not anything like that.
Well, but a
And
physician's group can be a hospital, at least as the statute defines it.
I wouldn't necessarily agree with that. A physician's group can't necessarily be a hospital unless it's licensed as a hospital. And, unless there's some physician's group out there that owns a hospital and runs a hospital.
Well, the definition of hospital includes any corporation that is licensed as a hospital, which you indicate, or any person, corporation, association, board, entity, authority that is responsible for the operation of any clinic that employs full-time staff physicians practicing in one or more recognized medical specialties and rendering care, treatment, et cetera. So it's not hospital like a layperson would think about. Obviously that would qualify, but it's also, there's a more flexible component to the definition that would include what, as I read that, also physician groups.
Well, a physician group arguably could own a hospital under that definition, and it would need to be licensed as a hospital. But then if you jump into the second part of that definition, also includes, a clinic that is run by a physician, anybody. There's a list of people that can run a clinic, but it has to employ a full-time staff of physicians. They have to be in different medical specialties. And it has to be an actual location, i.e. a clinic. It doesn't say, so some sort of medical group or anything else like that. Mayfield didn't present any evidence at the trial court level that it was a clinic or that it met the definition of hospital. So even though that is possible for purposes of the appeal, there's no evidence in the record that Mayfield, even though it calls itself the Mayfield Clinic Incorporated, is anything more than a physician's group. And even though it may call itself the Mayfield Clinic, it didn't rely on that in its motion for summary judgment. It didn't rely on that in its response brief as the appellee in this case. Instead, it basically just said, nope, vicarious liability claims against physician groups are barred by the statute of repose if you bring that claim against a physician. So this court does not need to address or decide that issue today because that issue wasn't addressed or decided at the trial court level. And that issue was not brought up by the appellee as, applicable to this case. What Mayfield is basically saying in their assertion of the affirmative defense of the statute of repose is that because the claims against Dr. Tobler were barred by the statute of repose, any vicarious liability claim against Dr. Tobler's employer, i.e. Mayfield, is also barred by the statute of repose. And that is not correct. And that is what the trial court's decision is based on. So going down that, it's hopeful that I've been able to convey through the case law that I've cited in my brief, as well as my arguments here today, that even though there may be a medical claim against a medical provider, that medical claim may exist outside of 2305.113. And this was recently recognized by the Southern District of Ohio in that Notario case that I was cited in my reply brief. And they did a fairly comprehensive analysis. And it was a blood clinic and that they were using, and they were getting people's blood. And there were claims against the blood clinic with regard to that. And the Southern District of Ohio basically said, no, applying this law of Stevick from the Supreme Court of Ohio, not all claims alleging, medical negligence in Ohio are medical claims under 2305.113. Instead, you got to hit both parts of the statute. Here, we've conceded that the first part of the statute is hit. In other words, it arises out of medical treatment, but we do not concede. And instead, we do not believe that the trial court even correctly analyzed or found that the second part of the statute was found. There's no discussion in the trial court's decision that the Mayfield Clinic is an enumerated provider in 2305.113. There is no decision by the trial court that there is any application of the definition of hospital to defendant Mayfield. And instead, there was no evidence presented at the trial court level, which would allow a court to decide that on summary judgment. This issue was raised to the trial court. We objected to summary judgment saying, hey, you can't apply this 4-year statute of repose in 2305.113 to a provider that is not shown that it is subject to 2305.113. And the trial court ignored that argument and basically said, nope, vicarious liability claims against a doctor or against any provider that are based on a doctor's negligence are subject to 2305.113. The trial court made 2 errors. The first error is that, which is just because you sue any provider, that provider's employer automatically gets the benefits, the protection under 2305.113, which is incorrect. And the Supreme Court has said that is not correct. And recent decisions from courts of appeals have said that is not correct. And the Southern District of Ohio has recently spoken and analyzed this issue very concisely in that Ontario case and has said that is not correct. In other words, you can have employees who get the benefit of 2305.113, but an employer who doesn't. It's how it is. If the statute wanted to be written differently, the legislature could have written the statute differently, and they've amended the statute multiple times since its original enactment and have not made that decision. So the trial court was wrong there. And the trial court was wrong to grant summary judgment in favor of Mayfield based on that. So we would ask, obviously, that this court reverse that decision and say, no court, no trial court, you got that wrong. You got the issue of Mayfield being subject to 2305.113, subject to 2305.113 based solely on Dr. Tobler being subject to 2305.113 wrong. Reverse the decision, send the case back down to the trial court. The trial court will need to proceed and do what it does next. That is the issue that's being appealed here, whether or not it was appropriate for the trial court to grant summary judgment based solely on that issue of vicarious liability. Now, if this court jumps into the analysis, which was not raised by the appellee, not raised in my briefing as well, and is also not raised in the trial court's decision with regard to summary judgment in this case, as to whether or not Mayfield is a quote unquote hospital or other enumerated provider, we would state, the appellant would state, that there's absolutely no evidence in the record that Mayfield is a hospital or other enumerated provider. There was nothing presented in their briefing for summary judgment. There was no deposition testimony provided on that, no affidavit testimony provided on that. Our complaint does not allege that. And instead, it basically says Mayfield's liable for medical negligence. That's it. They can be liable for Mayfield can be liable for medical negligence and not be subject to 2305.113. So with regard to that issue, this court, even though it may address that issue at some point in the future, we would argue that there's no evidence in the record that Mayfield has presented that, and no argument that Mayfield has presented that to this court. And it's kind of weird. And I've been doing a bunch of these medical cases and dealing a lot with 2305.113. And it seems strange that you can have like a provider that's, a human being that's subject to 2305.113, and then their employer who employs them that's not. But the 9th District found that in an ambulance case. Like the EMTs are specifically enumerated providers, but ambulance companies aren't. So the ambulance company, even though the EMT was subject to 2305.113, the ambulance company wasn't. So there's a whole bunch of other stuff that 2305.113 curtails. Obviously, there's difference in caps. There's difference in the statute of limitations. There's difference in requirements with regard to Rule 10. There's difference in requirements with regard to the statute of repose. There's all kinds of different things that come up with 2305.113 that the legislature has specifically set out. And they wrote a very, very, very comprehensive statute. It's not as if it's, 2 sentences long or anything else like that. It's pretty beefy. And it's got a whole bunch of information in there and specific issues in there. And even the Wilson versus Durrani case said this. Basically, it says, hey, the statute says what the statute says. And we've got a statute of repose, and it applies pretty harshly, but it is what it is, even if you're dead. the statute of repose is still going to apply to, all kinds of things. Even if somebody hides something from 4 years, boom, it's a really tough statute of repose.
Mr.
I've got
Schneider, you are at your time if you'd like to reserve 2 minutes.
I would like to reserve 2 minutes. I thank you, this court, for its attention to this case, and I do appreciate the time.
All right, thank you. Ms. Frankowitz, you have 15 minutes.
Thank you. Thank you, Your Honor. May it please the court. What appellant is proposing is a radical departure from the norms of respondeat superior to circumvent the statute of repose.
Well, let me ask you this.
Sure.
Is there any evidence in the record that Mayfield qualifies as a hospital or other provider under the statute?
There is not. The court in the
So why does that not establish that summary judgment was inappropriate?
Because you don't have to be an enumerated provider to qualify under 2305113. The liability comes through the acts of the tortfeasor through the doctrine of respondeat superior. And the Ohio Supreme Court in Sawicki was very clear on this. In fact, it's directly on point, where in Sawicki, a physician was sued and their group was named in the position of vicarious liability. The doctor was then dismissed later because he was immune, and the court held that the employer was still in the case because of respondeat superior. Respondeat superior imputes the acts of the tortfeasor to the employer, not the tortfeasor liability. So if the tortfeasor is not liable due to immunity, the acts are still imputed to the employer through respondeat superior. That's what that case held, and that's what we have here. Dr. Tobler, the actor in this case is Dr. Tobler. He did surgery, that's a medical claim, no question about it. Dr. Tobler was let out because he was immune. Therefore, the acts of Dr. Tobler are imputed to Mayfield. So because of that, 2305113 applies because Dr. Tobler is the enumerated provider and Mayfield stands in his shoes. It is immaterial whether Mayfield is an enumerated provider or not. Why? Because the reason 2305113 applies to them is due to the sound doctrine of respondeat superior.
What was the cause of action against Mayfield? I'm looking at it, I can't find it.
It's just vicarious liability. They just stood in this, it was against
So
Dr.
there was no negligent supervision, negligent hiring, anything like that?
No, absolutely not. So the only time that a clinic like Mayfield or hospital or corporate group would qualify under 2305113 is if there's a direct negligence medical claim against them. Against Mayfield here, it's not necessary. It's not necessary against any provider group because the provider is the actor and the group stands in their shoes through vicarious liability, through respondeat superior. Plaintiff claims that the Ohio Supreme Court supports his position, and I'm assuming he's talking about the Stevick case. The court never, ever said that if you're not an enumerated provider, that 2305113 doesn't apply to you. What happened in Stevick was the plaintiff sued a dialysis company. The patient was being lifted in a lift to get into the place where they needed to get the dialysis done, and he fell out or something happened where he was injured. They only sued the dialysis company. So it came up through the courts of appeals and made it to the Ohio Supreme Court. The Ohio Supreme Court said, when we look at the complaint, we can't tell whether this is arising out of, if they're asserting a medical claim, because what they had to do was determine the statute of limitations. Was it going to be 1 year under the medical claim statute, or was it going to be 2 years under ordinary negligence? The court said, and this is important, they looked at the complaint. They looked for the actions in the complaint that were imputed, that would then be imputed to the dialysis company. And because of the way the complaint was written, they couldn't tell whether an enumerated provider that would bring in 2305113 was stated in the complaint. So they sent it back to the trial court to say, hey, you need to figure this out because we can't determine based on the face of the complaint whether the medical claim statute applies or whether ordinary negligence applies. It never said anything about if you're not an enumerated provider, you, the dialysis company, then 2305 can never apply to you. That's not what they said.
So I just want to make sure I understand your argument. So you're saying that because he prevailed on immunity, that automatically means Mayfield wins?
No, we're not making that claim at all.
Okay.
Because the Sawicki decision by the Ohio Supreme Court would prevent us from arguing that. What Sawicki said was, even though the doc is gone on immunity, the group stands in his shoes,
okay,
which is what we have here. You know, we're not claiming because Dr. Tobler was immune that we are not liable. What we're saying is 2305113 applies to Mayfield through the doctrine of respondeat superior. Therefore, the statute of repose applies, and Mayfield is entitled to summary judgment based on the statute of repose. So Stavic does not stand for anything what the plaintiff claims. Now, plaintiff talks about the Notario case in Wick, and this is very important because when the court digs into this language, you will find that Wick supports our position. Notario relies upon Wick, okay? In Wick, there's a Wick 1 and there's a Wick 2. Notario relies on Wick 1, which was the 2014 case. But there's a Wick 2, which is 2021 Ohio 635, that clarifies what they were saying in Wick 1. Notario doesn't even address that. What happened in Wick 1 is you had two claims. You had one claim against the EMTs, and you had one claim against the ambulance provider. There was a direct claim against the ambulance provider for delay in transportation. The court said that's not a medical claim because ambulances are not listed as an enumerated provider. Okay, delay in transportation is not medical care. So they said that's a direct claim subject to the statute of limitations for ordinary negligence. However, there was a second claim, which was against the EMTs, and the ambulance company was named as vicariously liable for the EMTs. The court in Wick said, you have to get an affidavit of merit to establish your claim against the EMTs, but you don't need one for the direct negligence claim, the separate direct negligence claim. So plaintiff goes back in his case. He never gets an affidavit of merit for the EMTs. Well, eventually, the EMTs and the ambulance company file a motion for summary judgment. It works its way back up to the 9th District. And the trial court granted summary judgment because no affidavit of merit was ever filed against the EMT. So when they came back up to the 9th District, the plaintiff said, wait, you told me I didn't need an affidavit of merit against the ambulance company. So even though the EMTs would be out, I still should be able to sue under the medical claim for them giving the morphine during transport. I should still be able to sue the ambulance company. The court said, whoa, no, that's not what we said at all. What we were talking about is the direct claim for the delay of transport. Of course, you don't need an affidavit of merit for that because that's an ordinary negligence claim. But you had to have established the claim against the EMTs and able to keep the ambulance company in the case on the hook under 2305113. You failed to state a claim against the EMTs. Therefore, you failed to state a claim against the ambulance company for the morphine injection. And then what else happened was that the plaintiff never did support their direct claim of negligence against the ambulance company. And so they also got their direct claim dismissed. So when Notario takes the Wick 1 language, they seem to be saying, oh, we can separate between the EMTs, even though it's on the vicarious liability claim, we can separate the EMTs and apply this statute of limitations. again, and then against the ambulance company for the vicarious liability. That's not what WIC said or stood for at all. And so it's very important that the court understand the facts under WIC 1 and WIC 2, and then you'll understand that Notorio was completely off track and should not be relied upon. It took WIC out of context, and it should not be relied upon at all. You really need to dig into WIC 1 and WIC 2. The other thing for this court to consider is the impact. If this decision is made in support of plaintiff, the impact on the cases across the state of Ohio. If this is the case, if you're allowed to separate because you're not an enumerated provider and you can apply a different statute of limitations, you've got 2 statutes of limitations that will apply. Plaintiffs can circumvent the 1-year rule under 2305-113 by just naming the group, and they can circumvent the statute of repose, even though it's a medical claim that arises out of the care and treatment of the patient. That's what's going to happen. And the Wilson court said 2305-113 is a true statute of repose that clearly and unambiguously precludes the commencement of a medical claim more than 4 years after the occurrence of the alleged act or omission. Alleged act or omission. It doesn't talk about enumerated providers. It talks about the act. Dr. Tobler is an enumerated provider under the statute. It's his act that forms the basis of the claim. Therefore, summary judgment is appropriate for Mayfield because the claim was filed outside the statute of repose. And I would take it even further in my closing to say, imagine what this will do at the trial court level. If this is the case, what do we do at trial? What's the proper jury instruction? If the group is in because of ordinary negligence, isn't the ordinary negligence? I couldn't hear what you said. Isn't the ordinary my Siri? Isn't the ordinary negligence the correct jury instruction at that point? Well, no, it's not. It's standard of care. It's standard of care of a physician. So you can see how this doesn't work. His proposal doesn't work. It's going to cause havoc across the state of Ohio. And I would ask that this court affirm the trial court's granting of the motion for summary judgment. Thank you.
Ms. Frankowitz, any questions before we move back to Mr. Schneider? Mr. Schneider, you have 2 minutes remaining. You may begin.
Thank you, Your Honor. With regard to Ms. Frankowitz's kind of later points about the effects of a decision in my favor would have, I mean, obviously that's really an issue for the legislature. I mean, if they can amend the statute like they've done 6 or 7 times before to add in additional enumerated providers if they want. The Wilson versus Durrani case is pretty clear that the Supreme Court says, look, the statute says what the statute says. And if it's harsh for somebody who's bound by the statute of repose, and it needs to be interpreted that way, it is what it is. And that's what happened in Durrani.
Let me back up to the question I first asked you when you started, though. If the only liability of Mayfield is vicarious liability, and that means that they do stand in the shoes, why isn't Ms. Frankowitz right about the statute of repose? And if we accepted your argument, wouldn't it apply in every medical case, even if the only liability is vicarious liability? For statute of limitation and statute of repose and anything else?
I'd like to answer the first part of your question and then seek clarity on the second part of your question. With regard to whether or not vicarious liability is a derivative claim that is subject to 2305.113, the drafters of 2305.113 specifically wrote out what they included to be medical claims and derivative claims for medical claims. And they've got a list in there. And it's like claims for loss consortium and claims for, by the family and other things like that. If the legislature wanted vicarious liability derivative claims to be subject to 2305.113, they would have put those in there. There's a big long list of them. and vicarious liability claims against employers are not included in there.
So let me
Go
make
ahead.
sure though I understand. So is it your position that if the claim is barred by the physician for the statute of repose, that the group would still be liable 8 years later because they're not the physician?
To answer your question very directly, Judge Myers, yes. And the reason being is it's not that they can still be liable. And, you know, the physician arguably is also liable, but the claims are barred by the statute of repose. That's the deal with the statute of repose. It basically just says, you know, we're cutting it off. And if the legislator wanted that statute of repose to apply to, you know, a medical group that employs a physician, they should have written it into the statute. And it is what it is, basically, when it comes to statutory interpretation. It's not included in there, and it doesn't appear that it should have been included in there because the derivative claims language is included in there and doesn't include derivative claims for vicarious liability. The trial court of Court of Appeals or even the Ohio Supreme Court can't add that language in there. There is no language in 2305.113 which prohibits vicarious liability claims being brought against a physician's group because the physician is subject to 2305.113. And that's exactly what Sawicki says, basically, with regard to immunity. You can still have vicarious liability even if there's immunity. That's what Wick and Notario say with regard to the application of 2305.113. It can apply to the employee, but it doesn't necessarily apply to the employer. Now, if the employee ends up getting
Mr.
out—
Schneider, you are at your time, but I'm going to let you finish that thought.
Okay. So, for example, in WIC 2, where there's no affidavit of merit provided, if that claim gets knocked out against the employee, then obviously the claim would be knocked out against the employer. You know, you can't prove liability on the employee because you don't meet the requirements. You know, that's out. However, this case involving Dr. Tobler is different. He got out on immunity. He didn't get out because he wasn't negligent or because we couldn't prove negligence on him. We had an affidavit of merit filed against Dr. Tobler. They said, nope, he was supervising a resident. He's out. So Wiki allows basically our claims to continue against Dr. Tobler, or not against Dr. Tobler, but against Dr. Tobler's employer. So eventually, the trier of fact is going to determine whether or not Dr. Tobler did something wrong and whether or not Mayfield's responsible for that. However,
at that point, it's a medical claim, right? I mean, you're
it's
going
a medical,
to be saying
it's a
he
medical
committed
malpractice.
medical negligence.
Yeah, it's a medical negligence claim that's not covered by 2305.113 because Mayfield is not an enumerated provider under the second requirement under that. That's exactly what this case is about. This case right here is about that issue and that issue alone. Not what other effects it's going to have, not who's liable or anything else like that. The trial court was wrong to grant summary judgment on the issue of vicarious liability, finding that prevented the claim against Mayfield. It doesn't. We would ask the court to reverse that decision. Thank you all very much for your time today.
All right. Thank you. Counsel, thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion. Ms. Hayden, if you can bring the next parties into the courtroom.
Thank you, Your Honors.
Thank you.
Mr. Cumming, I don't know if you want your camera on, but at the moment it is not on.
Sorry about that, Your Honor. I'm getting a prompt that says cannot start video.
Oh, well, it's fine if you want to proceed without the video.
That's fine with me, if it's all right with everybody else, yes.
Yes, it's fine with us. And if you figure out how to make it work, we'll welcome you in at that time. The next case on our docket this morning is State versus Curry. Mr. Perkins is here on behalf of appellant, and Mr. Cummins is here on behalf of the state. Mr. Perkins, you have 15 minutes to argue this morning. Would you like to reserve any in rebuttal?
Your Honor, I believe that Mr. Cummings is the appellant on this one.
Oh,
Yes, Your Honor,
I have the wrong briefs in front of me. Pardon me.
that's all right. I would like to reserve 10 minutes if I could.
All right, and you may begin when you're ready.
Thank you. Your Honors, I think this case represents a very straightforward application of this court's precedent in State versus Howard and most recently in State versus Ulmer. We have a case here where the officer testified that he smelled raw marijuana coming from the trunk of a vehicle. And based upon that odor of raw marijuana coming from the trunk of the vehicle, he felt he had probable cause to search the trunk, and he did so. And it's the state's contention that that decision to search the trunk was constitutionally permissible because he testified to what he had to do to search the trunk. He laid out that he had been trained at the police academy and distinguishing the difference between burnt and raw marijuana. He's done it before. He knows the difference. And he smelled it not only from the cab of the vehicle, but also from the trunk.
So, Mr. Cummins, what do we do with the defendant testified to the contrary, and obviously there was no marijuana in the trunk when it was opened, and I know the judge said something to the effect of, like, I find everything credible, but there's a clear conflict between the testimony here, and what do we do with that?
Well, Your Honor, I think the trial court said he found all the testimony credible. And I think what that means is he believes the officer when the officer smelled raw marijuana coming from the trunk. And he also believes the defendant when the defendant says that I think the cop's lying. I think you can see all of that as credible. And I think that's what happened here. I also think that this court is bound by this finding of fact. And in that sense, what I mean is the trial court seemed to find the police officer credible. And I guess he found the defendant credible as well.
Well, but I guess I'm going to push back on that because I've read that transcript of his decision several times. And granted, it leaves a little bit to the imagination, but I'm trying to understand, why did the court grant the motion to suppress? And as I read his recitation, he talks about cases where officers did not have probable cause to search the trunk. And so one reading of that transcript is that he was discounting the officer's credibility because that's why he's talking about these cases. But I'm having difficulty reconciling those two. So any insights would be appreciated.
Well, I'll tell you what I think. I think that the key is what he says. He seems to think that the small amount of marijuana, the small shakes found in the cab of the car, were just insufficient to warrant a search of the trunk. He says the search was done due to a small amount of marijuana. I think he was hung up on that factor. But of course, we have much more than that. We have the officer here saying that he smelled it coming from the trunk, and that's where this Court of Appeals comes in. If the facts are in the record that support probable cause, it's this court's duty to step in if the trial court misapplied the law to the facts. It seems the trial court here didn't think the law allowed for a search of the trunk based upon the facts that he found credible. And that's just an error of law. And I think that this court can point to its previous cases and say that the trial court erred in saying that the officer's testimony didn't demonstrate probable cause. Based on this court's precedent, it certainly did. I don't think that the trial court disbelieved the officer. I think he just didn't think the small amount of marijuana in the scheme of things justified the action. But it did under the law as it stands in this district in the state of Ohio. And that's why the state brought the appeal. I would like to make another point, I guess, in passing. I think that there seems to be a tendency lately to mischaracterize investigative detentions as illegal arrests and then suppress evidence found as a result of that illegal arrest. But that's not what's going on in these cases. It's certainly not what's going on here. This was not a search incident to an arrest. It was a
Well, but doesn't that point concede that it was an illegitimate arrest? Because I kept waiting for you all to make the argument that it was a search incident to the arrest, and you don't make it. And my supposition is because the arrest was illegitimate.
No, he wasn't arrested until they found the firearm. He was detained in the cruiser, but that's simply a detention that can be made pending an investigation as long as the officer has a reasonable suspicion that there's criminal activity afoot.
So you don't think he was arrested when he was hauled out of the car?
No.
Okay.
Actually, as this court held in, I believe, City of Cincinnati versus Blair, to have an arrest, you need 4 elements. You need the intent to arrest, the actual detention by real authority, and the person arrested has to understand they're under arrest. It fails to meet the very first element here. The officer specifically said that he did not intend to arrest this defendant when he put him in the cruiser. And this was actually made clear in the transcript when the defense counsel said he was under detention, not arrest, correct? And the officer says that's correct. So that this whole detention arrest controversy is a red herring here. He was detained until the officer completed the investigation. Once they searched the trunk and found the gun, then he was arrested.
Let me ask you one more question about the stop, because it was based on a window tint issue. And I guess one thing that troubled me about the officer's testimony is he seemed to indicate there is no legal standard for that, and that's wrong, isn't it?
Well, I think the law changed in 2019, and I think you have to be able to see the occupants of the vehicle. And I think there's a gray area there. I understand that. But I do think that it was a legitimate stop here. And that wasn't really contested.
Mr. Cummins, you have about 3 minutes left if you want to reserve 5. And if you'd like to reserve the remainder, you'll have 8 minutes left.
I'll reserve the remainder, Your Honor. Thank you.
All right, Mr. Perkins, you have 15 minutes.
Good morning, Your Honors. Your Honors, I think that the issue is the state wants the court to believe that the trial court made a factual determination that it actually believed the officer that he smelled marijuana coming from the trunk. And I don't believe that is the case. The court never reaches that conclusion. And I think that it's right that there is a conflict between what the officer is saying about smelling the marijuana and what Mr. Curry is saying about, hey, there's never been marijuana in my trunk. There's no way that there was an odor of marijuana coming out of my trunk. And that's for the trial court to make a determination and decide who it believes. I think that the comment that it found all the testimony credible, I don't believe rises to the level of that he believes the officer.
Well, then how you heard my questions, Mr. Cumming. I mean, how are we supposed to interpret kind of the cryptic references in the transcript here? Because I'm struggling with that.
Well, I think the way the court should interpret it is that, yes, there is a conflict, but the trial court, in reaching the decision that it did, resolve that conflict. But I don't think you can. I think the only way this court can reverse this case is to say that there was a finding of fact by the trial court that the officer did in fact smell raw marijuana coming out of this closed trunk, even though there was not marijuana in this closed trunk. So I don't think that fact has been proven, or even that the trial court found that to be the case. I think the trial court said, hey, this search of the trunk exceeded the scope of the stop, which clearly it did, which is consistent with the officer not smelling believing that the officer did not actually smell the marijuana coming from the trunk.
Would you agree that that's the key issue in this case, is whether or not factually the court believed that the officer smelled the marijuana? Because if so, then don't we have to reverse? And if not, then don't we have to affirm?
I think it's an important issue, but I don't think it's key, because I think if you go back even further, this stop, in my opinion, was bad from the very beginning. We have a police officer that is saying, hey, there's no standard out there for me to stop a car with tinted windows. That is absolutely not true.
Mr. Perkins, let me suggest that at least my reading of the motion to suppress doesn't suggest that counsel argued that it was a bad stop.
I agree that it was not specifically argued. However, when he was questioning the officer about it, he did go into he asked about the window tint and seemed to be satisfied with the officer's misconstruing the fact that there was no standard. But he did in fact bring up during the cross-examination of the officer the issue regarding the window tint.
Wasn't that objected to by the state as beyond the scope of the motion to suppress?
I don't recall off the top of my head. I know that even in argument that the defense counsel believed that the law had changed as it related to the window tint, which wasn't accurate. But even if you say, okay, there was a basis to stop it for the window tint, I think it's disingenuous to say that this was not an immediate arrest. They stopped the car. They immediately pull both of these subjects out of the car, put them in handcuffs, and put them in the cruiser. Their interest is not in writing a citation for a window ticket. They put them in the car, and the officers go back to the car, and they're searching the car. And the officer admits the worst thing that happened at that point was a window tint violation, which was a minor misdemeanor. I think it's disingenuous.
Well, he couldn't have been arrested for that anyway, though, right?
Right. That's a minor
So
misdemeanor.
there wasn't an arrest because there couldn't have been one. So he was
there
just
can be an arrest,
detained.
but there could not have been a lawful arrest. But I believe that was arrest when you immediately, this wasn't like a stop where he walks up to the car and says, can I see your license and so forth, and he's detaining him for that purpose. This was immediately the task force stops him, pulls open the car, pulls him out, handcuffs him, puts him in the car, and goes back in the cruiser and goes back to his car to search.
What did the officer say? I can't recall. What did the officer say was the justification to handcuff them and place them in the cruiser?
I believe his justification was officer safety, but again, he does not. This is not a Terry stop. He admits it's not a Terry stop.
Yeah, I mean, they didn't pat them down, did they?
No. Well, that's not in the. He's not in the record about patting them down. So, yeah, I don't believe that there's any testimony regarding patting him down. There's no testimony regarding, I felt that he could have been armed, or this is to investigate some other matter that we saw that gives us reasonable suspicion to detain. The officer was clear. The reason they stopped him for tint, the reason that they whether you call it arrest or detention, was for the window tint. But their goal, again, they never go and start writing a ticket for window tint or anything. Their goal is to get into that car and conduct a search, which is what the gun task force does. Is they go out, they stop people for minimal offenses, immediately arrest them so they can get inside the car and search. And in this case, it's very troubling that you have an officer there saying, oh yeah, he knows what to say. I smelled raw marijuana coming out of the trunk. Well, and again,
it can never be proven wrong on that, right?
Absolutely. Oh, I smell it. Must have been in there.
Well, but so I hear you, and I have a lot of concerns about the stop, but I want to go back to Judge Meyer's question, which is, if the trial judge said, I believe the officer's testimony that he smelled raw marijuana in the trunk, that would justify the search, would it not?
Yes, if the stop is legal and the officer's where he's legally entitled to be, and he truly did smell marijuana, and the judge believed that he smelled marijuana, then I agree that would be an important issue. But again, I don't think from your job as far as applying the law versus the trial courts determining the fact, the record simply does not make a determination that the trial court believed that the officer smelled that marijuana. I think you can interpret it the way he ruled is quite the opposite, that he didn't. Did he want to come out and say this officer was not telling the truth? Probably not. I mean, who wants to do that? But by saying that it exceeded the scope of this stop, I think that's what because the scope, obviously, if you believe what the officer said, then the scope would have expanded at that point in time. So to say that it exceeded the scope, I believe is the court saying, no, I don't believe that, or that there has not been sufficient evidence presented that this officer truly did smell marijuana coming out of this closed trunk, because there was no marijuana there. And then again, as it relates to the judge, the cryptic statement about I find all the testimony credible, well, that can be equally applied to Mr. Curry, who said there's never been marijuana in the trunk of the car. There's no way that the officer smelled marijuana. So that can be applied to that. Plus, the reality of the situation goes with Mr. Curry that there was no marijuana in the trunk.
Mr. Perkins, you have some time remaining, about 6 minutes if you'd like to use it.
And again, I think we can also, I don't think that the stop, while it's important, the point of the officer, whether or not he smelled that marijuana, I think, again, that this stop is bad going back from the very beginning, there is no legal standard to stop for tint that the officer testified to. That's not the case. If you look at other cases that talk about probable cause to stop for window tint, they talk about, oh, my lights, I shine my flashlight in it and couldn't see inside the car. In this case, there was never any testimony from the officer about light transmittance through the window. He just simply said, I couldn't see who was in the car. Well, of course he couldn't.
But going back to Judge Winkler's question, though, this wasn't argued in front of the trial court, and the trial court made no findings about the stop, did it?
No. And I agree that the factual findings are a little bit sparse. And it was not a main point that was argued in the motion. But I don't think the court can not, if the court is considering the scope, whether this was within the scope of the search, I think the court can look at the initial stop, what the officer's belief was, whether or not there was probable cause to even arrest for this offense. I think the court can take all that into consideration, and is the end result reached by the trial court, is it a correct decision? And in this case, I believe it is. But I don't think we just need to stop at when the officer was standing by the trunk and supposedly smelled this phantom marijuana. I don't think we need to stop there, because there was a whole lot that happened before it that goes to the issues of credibility as well, which was the trial court's province to make that determination. And I think it made its decision based upon how it weighed both of the testimony that was given. There's certainly nothing in the record to indicate that the trial court did not believe Mr. Curry when he said there's no way that this officer smelled marijuana, because there's never been marijuana in my trunk. So yeah, there's no doubt the record's not as clear as it could have been, but I think that the only way that this court reverses is if it makes a factual determination that was simply not made by the trial court. So we would ask the court to affirm it.
All right, thank you. Any questions for Mr. Perkins? Mr. Cummins, you have 8 minutes remaining.
Thank you, Your Honor. I shouldn't take that long. I want to make a couple of quick points, though, to put this in context. The reason they were cuffed and taken out of the car was because his assisting officers saw furtive movements being made in the passenger side of the vehicle. They couldn't see. It was dark. It was dusk. They couldn't see through the tent. They opened the door so they could see, and they saw furtive movements. And you have to take that seriously in this day and age. There's a war on police in our country right now. They did the right thing for officer safety by cuffing these people and putting them in the cruiser while they investigated. That's the first point. The second point is you don't evaluate the propriety of a search after you find out what the search discovered. You must evaluate the propriety of the search based upon the inception of when the search occurred. And based on
so let me ask you the flip side to the question that I asked Mr. Perkins, which is, if the trial court concluded that he did not find the officer's testimony credible about the smell emanating from the trunk, then we would have to affirm the judgment. Is that would you concede that or not?
Yes.
Okay.
In fact, a lot of times in these cases, when, it just comes down to the trial judge just not believing the officer, we really can't appeal, because that's really the trier of facts call. And if they don't believe the officer, that's the trier of facts job, and that's their option. That's why I thought it was important just to mention what this judge said here, because I do think it's very instructive. He went out of his way to say that he thought the officer's testimony and the defendant's testimony was credible. So what that tells me is this ruling was not based upon not believing the officer. It was an error of law, and that's exactly why we appealed. For some reason, he was looking up the Elliott case, which is a federal case about a consent search. I don't understand why that was being referenced and evaluated by the trial court. I think what we have here is an error of law. And I think this record supports probable cause, just like this court found in Howard, where the officers said, hey, I smelled raw marijuana in the trunk. This court upheld the search because that gave the officer probable cause. Just 5 months ago in Ulmer, Judge Myers, you sat on the case that went out of its way to say that, hey, we don't have a case where the officer smelled raw marijuana and testified that he can distinguish it. Maybe if that had been the case, this would be a different result. That was this court's decision just 5 months ago. So by these courts' past decisions, we clearly have probable cause on this record. And I don't think it's a big mystery. I think the trial court just made an error of law. And I think that's why the Court of Appeals is here to say, hey, look, based upon the law and the facts, this was an error of law. There was probable cause here. And really, unless the court has any specific questions, that's the gist of the state's argument in this case, Your Honors.
Does this panel have any additional questions for Mr. Cumming? No. Thank you both for your arguments this morning. We will take this case under submission and give you a timely written opinion. And Ms. Hayden, if you will bring the next litigants into the courtroom.
Thank you, Your Honors.
Good morning. The final case on our docket for argument this morning is N. Ray A.Y. Mr. Thompson is here on behalf of appellant. Mr. Havlin is here on behalf of appellee. Mr. Thompson, you'll have 15 minutes to argue this morning. Would you like to reserve any time for rebuttal?
That's Your Honor.
How long?
5 minutes.
Thank you. And whenever you're ready, you may begin.
May it please the court, counsel. While we argue that AY was not the person who committed the offenses in question, my focus today will be on our argument that regardless of who committed those offenses, they should not have been adjudicated of aggravated robbery, firearm specifications, or having weapons while under disability. The reason why is twofold. First, the evidence presented in the case showed that a BB gun was used, and without an operable firearm, the offense would be robbery, not aggravated robbery. Would not be any.
I guess I'm not sure that's accurate. The evidence showed that a gun of some sort was used during the robbery, and then subsequently BB guns were found at your client's residence. So there's a disconnect between the BB guns there and establishing that the gun used in the robbery was a BB gun. So help me out on that.
Well, my position there is that one, Detective Zopfi testified that he himself thought it was a real gun, that he could not distinguish the Glock BB gun that was found from a real gun until he looked at it closely. And frankly, they found the vest with the nacho cheese on it. I find it difficult to believe that somebody who would leave sort of the cheese out in the open to be seen would also be wise enough to dispose of a real gun. And two, that if the actual nacho cheese vest is at this place, that those weren't the guns that were also used. So I think the extremely weighty evidence is that they found both the correct vest and the correct guns that were used, or gun that was used.
But weren't there two?
Correct, but one in particular, Detective Zopfi seemed to believe matched exactly the sort of gun.
I mean, I guess, like, I appreciate the predicament this puts your client or other similarly situated clients, but to establish proof beyond speculation that those guns were the ones used, like, I don't know that there needs to be testimony from him that yes, that was a BB gun that I used, but there needs to be something more than it was in the same room, because I'm not sure that's sufficient.
Well, it's sort of a ancillary issue, and it didn't come up, but the counter argument off to the side would be, well, then why were the guns presented at all? Were they not unlike, I forget the case name, but the murder case out of the Ohio Supreme Court where the knife collection was presented? I think if these weren't the guns, then they should have never been presented at the trial, that they would have been inadmissible and prejudicial. That didn't come up, but I think that these guns were presented because they were believed to have been the gun that was used. And then the magistrate went off the rails and used I shouldn't use that term. I'm sorry. I apologize. The magistrate used AY's silence against him for not coming up and saying, well, I was the robber and that was the gun I used, as substantive evidence that he was guilty of aggravated robbery.
Well, or as you're arguing, if the guns were admissible because they might have been the gun used, it would be up to the trier of fact to determine whether the state established beyond a reasonable doubt that a real gun was used. And the trier of fact could consider all of the testimony, including the inference that the guns found were the guns used. And in this case, the trier of fact rejected that inference and said, based on the testimony of the victim, I find beyond a reasonable doubt that it was a real gun. Isn't that permissible?
It would be, but for the statement that about AY being unwilling to make a statement to the officer, if the opposite assumption there is that the magistrate would have believed that the BB gun was the one used had AY simply either made a statement or testified that, yes, that was the gun. I think that statement, taken with the fact that the gun was found, that Detective Zopfi thought that that gun was real, that Mr. Carrizon thought the gun was real, really shows that the weightier evidence is that that was the gun.
Let me ask you, Mr. Thompson, we all watched the video of the robbery in progress, and I know Mr. Carrizon obviously thought that gun was real, or he wouldn't have shot at a teenager wielding a BB gun. Is there anything we can take from that?
Well, I certainly do believe Mr. Carrizon thought the gun was real. But I believe that it is at least some evidence that the gun was a BB gun and that the robber didn't shoot back. I mean, at that point, he's being shot at and is trying to get away. It's at least plausible to believe he would have fired as well. And I really think that the state kind of tried to have their cake and eat it too, that, you know, this is definitive evidence. We went to this house, we found this vest with the cheese on it. This is the house where AY lives. We found these guns. This is obviously him. That's the robber. But it's an aggravated robbery because we don't want to take the extra step to prove that this was 100% the gun used, but it matched. They just didn't do any sort of scientific testing on it. So we're sort of left with this catch-22.
Well, but is there testing that they could have performed on the gun to establish it was the gun that was used in the robbery?
Probably not definitively the gun, like scientifically this is the gun, but it certainly could have been evidence that, say, AY's DNA or fingerprints were on it.
Well, let me ask. I'm
sorry.
Go ahead, Mr. Thompson. Go
If it was, in my experience with DNA cases, the more DNA that is found, the more recent the DNA is.
Mr. Thompson, if the state had not introduced the two BB guns, wouldn't you be in a position now of arguing that it's exculpatory evidence and they should have introduced those guns into evidence?
I think that it would have been up to us. If they had not turned them over, we would be having an argument about whether it was exculpatory and should have been turned over. But I think that ultimately would go to trial strategy. But yes, I think if there were no guns, we would really be stuck with somebody believing the guns were real, and the case law is very bad for us on that.
You have about 2 minutes left if you want to reserve 5.
Okay. I just also wanted to reiterate my position that in this case, AY's silence seemed to have been used as substantive evidence that he was guilty. He was put in the position that to get on the stand and admit guilt after denying everything in order to minimize the punishment he received. And I believe that also was improper. And taken together, we'd ask the court to reverse AY's adjudications, and I'll reserve the remainder of my time.
Thank you, Mr. Thompson. Mr. Havlin, you have 15 minutes.
Thank you, Your Honor. Good morning. Alex Havlin on behalf of the state. I'll briefly start since Mr. Thompson just left off on the first assignment of error. I don't think it's certainly error to bring up that. I think it's harmless beyond a reasonable doubt. And it's because I don't think at any point this was used in order to adjudicate AY of this. And that's for a couple reasons. I tend to agree that the magistrate, I don't think it was a great choice of words, but he was adjudicated based on basically the victim's statement. And there was a lot that corroborated that. You all have the video and other things found, but the victim testified, I know this person and I absolutely believe that was a real gun. That's what he was adjudicated of. Now, the officer says the only way we could have known if it were one of these pellet guns was through his testimony. I disagree with that also, but that's not the evidence that his adjudication is based on. So that's just the magistrate. Even if we were to assume that the magistrate used that to adjudicate him, I think because of the unique nature of juvenile adjudications and the fact that there were objections filed in this case, the juvenile court judge makes it clear that she did not base the adjudication on that. So I do think that any error regarding that testimony was harmless and did not contribute to the adjudication. That issue does tie in, I think, with the the next two assignments of error fairly intricately. As Mr. Thompson addressed, there's kind of two arguments there. One is identification. The second is whether or not there was a firearm. I'll kind of skip over the identification issue at this point and address, I think the firearm question is really what this case is about. Judge Bergeron, in your question to him, you use the word disconnect. I've been kind of looking at this like there's not a sufficient nexus, same idea, between the two pellet guns found at this house and the offense that occurred, given the victim's belief and his clear testimony that he thought this was a real firearm. The case law, as you are all well aware, and as Mr. Thompson just stated, and the statute that allows circumstantial evidence to prove operability is obviously in the state's favor in this case. The nexus, I think, and this is
so I guess like what's a defendant in AY's position to do, like in a circumstance like this? How could they ever prove that it was actually a BB gun without having to inculpate themselves?
So that's an excellent question. This has happened to me personally. You could ask the victim. Does this look like what you saw? And I have had a victim say, yes, that's the gun that was used. And it was a pellet gun. It was a similar circumstance. No, there was, I think, more time in that case had elapsed between robbery and then arrest. There was a search warrant. They found no real firearms, but found a BB gun, pellet gun, airsoft, whatever it was. And the victim said, yeah, that was it. That didn't happen here. And I understand, as you brought up also, Judge Bergeron, this is it's a tough situation, I suppose, but I think that's the reason the statute and the case law exists, because there shouldn't be, I don't understand any public policy reason to have a benefit accrue to someone if they were to dispose of a real firearm and then have those replica firearms waiting. I think that's the underlying justification for the status quo, I guess, as it is. And I think the other, I'm sorry. Oh, and Judge Myers, to your point, there was a question about why we presented these at all. I think it's just for a total picture of what was found. I Judge Winkler, as you brought up, if we didn't, I think we have a different problem of hiding the ball, so to speak. I think the detective said, this is all I found. These are made to look like real guns, but I don't know. I can't tell you what was used. He wasn't there. The only thing we have to go on at this point is the victim's testimony, absent some other questioning of the victim or something else. And I know Mr. Thompson brought up, we found clothes at the house and things like that. A couple things on that. I think the identification in this case is based on the victim saying, I know this person. If we only had clothes that were somewhat similar to what's in the video, we have a bigger problem here. Some of those clothes also, though, had the cheese, what was consistent with the cheese that was all over the scene on them. Another way that maybe they could do this, Judge Bergeron, is if some of that was on one of these pellet guns. Any other number of things could have helped, but whatever they are, they're not in this case. So I don't think that there's any way to really overcome the precedent and the statute at play in this one. Let me see. I don't have anything else specific on either the firearm or the identification. If there are no other questions, I just ask that this court affirm juvenile court's decision.
Questions for Mr. Havlin? Mr. Thompson, you have 6 minutes remaining.
First thing I'd like to note is I'm looking at page 29 of the trial transcript. This is the cross-examination of Mr. Carrizon. He initially had testified that the gun was grayish but on cross-examination, he confirmed that the gun was a black gun, and that was what he told the 911 operator. And I'm not arguing against the sort of status quo that when a gun is used and then not located, that using it like a gun is evidence, a strong evidence of operability. But the thing that's different here is we found a gun that for all intents and purposes appears to be the gun used. And I really think that's what sets this particular case apart. I'm not looking for.
Did defense counsel show him one of the pellet guns and ask him the question that Mr. Heflin posited?
No, he didn't. But he did clarify it was a black gun. And that's what was found. So not looking for a change in the law, but simply a recognition that the weighty evidence was that this was the gun used and that this should be a robbery and just a robbery. If no further questions, I'll submit on the brief.
Any further questions of Mr. Thompson? Thank you both very much for your arguments this morning. We will take the case under submission, give you a timely written decision. This will conclude the arguments this morning in the First District Court of Appeals. Thanks, everyone.